Aldi Stores Ltd and Marks and Spencer PLC.
Yes, Mr. Peterborough.
I and my learned junior Thomas Elias appear for Aldi, who are the defendants below and the appellants before you. My learned friend Douglas Campbell, one of His Majesty's Counsel, and Daniel Selmy appear for Marks and Spencer's, who are the claimants below and the respondents here. Pursuant to the November 23 missive from Lady Chief Justice Baroness Carr, subject to your Lordship's view, I will be dealing with grounds 1 to 5, and our respective learned juniors will be dealing with 6 and 7.
Absolutely fine.
And then there's a slight wrinkle, my lords. They were, the juniors that is, going to deal with also the respondent's notice, because that appertains to 6 and 7. But you may wish to take some points on the respondent's notice out of order. And so we're able to deal with however you wish to deal with it.
Well, I'm perfectly content for between the 4 of you to agree the order in which the points are dealt with. You can take it that we have read the judge's judgment and the various skeletons, both on your appeal and the respondent's notice point.
My lord, I'm grateful. My lord, pursuant to the questions that my Lord Justice Arnold sent to the parties last night, we've thought it might be useful if you were to see the EUIPO registered designs, and therefore we've actually provided a copy of that in the second supplementary bundle. I'm afraid it's not paginated, I don't think, but there's not very many pages and it's all fairly self-evident, but that's been put into your second supplementary bundle. My lord, so that by way of introduction, might I then open the appeal?
Yes.
My lords, the way in which I was going to deal with this, if I may, was very briefly deal with the background facts, very, very briefly, then very briefly deal with, in essence, the whole point of grace periods and priority dates in the context of obviously registered intellectual property rights. The reason for laying the foundation like that is then it will make it much quicker when I deal with grounds 1 through to 4. And obviously I was going to deal with those sequentially, but actually they naturally bundle together. Grounds 1 and 2 go together and grounds 3 and 4 go together. And ground 5 is really a wrap-up ground and should only take a few moments because it flows from the consequences, we say, of grounds 1 to 4. So the background facts, at first instance, this was a 1-day IPEC trial before His Honour Judge Hacon. Originally, there were 5 UK registered designs in issue with respect to 2 allegedly infringing bottles. The 5th design, which I'm going to refer to by the last 2 numbers, UK 76, was basically dropped at trial, if not even before. So that really didn't form a part of the trial. So you're only really dealing with UK 78, 80, 82 and 84. Now, when I wrote my speaking notes, which was before yesterday, I indicated that it was going to be a conflict between the UK registered designs and the 2 Aldi allegedly infringing products. We have actually got samples of those here, which we finally managed to get through security downstairs when one of your clerks kindly went down and liberated them, so to speak. So those are the allegedly infringing products. If you'd like to see them, I've shown them to my learned friend.
I think that would be helpful.
Yeah,
fine. Shall I pass them up now? To forewarn you, the batteries are a bit feeble. They do actually work, but not as well as they did originally. They've clearly been played with over the time. So to activate it, it's a standard thing. You press the bottom, second press puts it onto a flash mode, third press turns it off.
Yes.
You will have noticed from the judgment that the actual bottle shape
I beg your pardon, before
sorry.
we go on, do you have one of the Marks and Spencer product for comparison?
Yes.
Yes, well, we had a similar issue at security, but here it is. And again, the light isn't as strong as it once was, I think.
Works in the same way, does it? Press
Yes,
the bottom.
Yes, there's some instructions at the bottom, but you press the
Yeah.
centre of the bottom.
Thank you.
My lords, you will have seen from the judgment that the bottle shape itself is a registered design, but it's owned by a third party.
You say we will have seen that. I've noted the statement, but how do we know that? Is that something that's in the judgment?
Well, it's in the judgment, but also if you go to the supplementary bundle, behind tab 1 on page 45, that's the registered design.
Is the proprietor of that design?
If you turn the page, 2 pages to page 47 behind tab 2, it's entry number 3 on that table.
Right. But I may be misremembering. I thought Novagraph were a firm of patent and design attorneys.
Yes, I think they are the address. I think the actual name is just one second. It's Saverglass.
I think we get that, don't we, from paragraph 75 of the judgment.
Yes. I'm grateful, my lord. Yeah.
All right. Yeah. Thank you.
My lords, then moving to the background that I wish to lay out before you with respect to the issue of grace periods and priority date. The long and the short of it is, as you all know, because you've all been in various registered design cases before, there is a difference between unregistered intellectual property rights, like copyright, and registered intellectual property rights, like registered designs. And of course, with a registered design or any other registered IP, you obviously make an application, so that's the application date, and then there's a process in the office to which you've applied, whereby that application is considered, and then at a later date, the application will either be accepted or refused, and that will be, so to speak, when the actual registration is confirmed. So there's obviously a gap between the application and when the registered right comes into existence. And that's absolutely necessary if you've got some sort of registered process that requires even de minimis scrutinization by the office. Now, for some rights, like patents, that process can take a very long time. Other rights, like trademarks, it can take a shorter time normally, but can still take a very long time. But things like registered designs, the delay is very little. Sometimes a few days, that's exceptional, but typically a few weeks or what have you, or certainly no more than a few months. Now, in order to deal with the situation of events that occur after the application date and before the actual registration of the intellectual property right, you need certain provisions with respect to what may happen to third parties' actions. And with respect to the registered design regime, you can find these in the authorities bundle behind tab 18 at page 554. Now, in the UK, the governing registration is the Registered Designs Act 1949, which has been amended extensively. But what we need to look at the moment is section 3, capital C, which you'll find on page 554, and subsection 1. Subject follows: a design, when registered, shall be registered as of the date on which the application was made or is treated as having been made. So this actually therefore means that the rights arise as of the application date in normal circumstances. And there's then in subsection 3 a number of ways in which you can work out when the relevant date is. And what we have here is that under subsection 3A, in the case of an application which is treated as having been made on a particular date by section 14.2, 14.2 is the section to which I'm going to take you in a moment, which deals with priority date matters. Then the relevant date is the date on which the application was made. So we're focusing upon the application date.
Well, yes and no. 3A says in the case of an application which is treated as having been made on a particular date.
Yes.
And so the date on which the application was made must surely mean the date on which the application is treated as having been made.
Yes, my lord, which in a normal circumstance is the date when an applicant, let's assume we have no priority issues, no grace period issues, then the normal plain vanilla situation.
No, I understand that.
Right. Because the point is that everything else we're now going to look at, in essence, tries to change that in one shape or another. And it's the way in which that is changed, which in my view is important. Now, broadly, as I've said, the key touchstone date is the application date. And that's the date that's central, we say, not only to validity, but also for infringement. Now, there are two big exceptions to the application date being the central touchstone date when you're talking about validity. The first exception is when you can claim a priority date pursuant to section 14 subsection 2, and the second is the grace period issue. Now those are separate points. Now, with respect to both the priority date and the grace period, they operate so as to, in essence, affect the relevant date when you consider everything. And you have to look at, in my view, the policy, the purpose of the priority date issues and the grace period issues, and then see how that policy is implemented. And in my submission, it's an error to confuse the policy with the mechanism whereby that policy has been implemented. Now, dealing with priority date first, priority date issues arose quite a long time ago. They actually arose in the Paris Convention 1883, Article 4, capital A, subsection 1. I'm afraid this is not in your bundle because we thought it was not very contentious, but I'll just read it out. Any person who has duly filed an application for a patent or for the registration of a utility model or of an industrial design or of a trademark in one of the countries of the Union, that's the Paris Union, or his successor in title, shall enjoy, for the purpose of filing in other countries, a right of priority during the periods hereinafter fixed. So, the whole purpose of the priority date philosophy is to allow a person to file in one country of the Union and then to file in another country of the Union. And in Article 4, capital C1, the period that is fixed for industrial designs and trademarks is 6 months. Now, 1883 was obviously a time when it was difficult for a proprietor of an industrial design to coordinate simultaneous filing in many different jurisdictions. So the whole purpose of this is to allow a party to file in one jurisdiction and then to file another design in another union country at a later point within the 6 months period, so as to claim priority back to the original filing date. So the purpose is to ease the mechanism of filing in different countries, and the way in which it's done is by giving a 6 month period in which you can do that second or multiple filings. Now, the whole point that you need this is because if you do not have a priority date mechanism, if you file in one country and then you were to file in another country, the first filing would invalidate your second filing.
On the assumption that you've got worldwide novelty or other grounds of invalidation. If you had grounds of validity that were restricted to prior art and available in the jurisdiction in question, the problem wouldn't arise.
But broadly, the point is to avoid self-invalidation and also invalidation by other intervening third parties in the period after the first filing. Because normally everything is assessed at the filing date, at the application date. And this mechanism allows you, for the purposes of validity, subject to what my Lord Justice Arnold has said, to ensure that you can have a period of time in which you can file in other countries because of the logistical problems of trying to do that in the 19th century. Now, if you're going to claim priority, there needs to be strict identity between the original filing and the subsequent filing, the filing that claims priority. And you can see that clearly from the Samson case, which is in the authorities bundle behind tab 7 at page 170. At paragraph 33.
Sorry, just give me the reference again, Mr. Edinburgh.
Yes. Authorities bundle, tab 7, page 170.
Yes.
Paragraph 33, top left-hand corner. A priority claim relating to the same design or utility models requires identity with the corresponding community design without addition or suppression of features. So it's a strict test of identicality if you're trying to claim priority. Now, what is the effect of claiming priority? Here we need to go back to the Registered Designs Act, which is behind tab 18 of the authorities bundle. And this time going to page 5.1, and we're looking at section 1, capital B. So, subsection 1, a design should be protected by a right in a registered design to the extent that the design is new and has individual character. Subsection 2, for the purposes of subsection 1 above, a design is new if there's no identical design or no design whose features differ only in immaterial details have been made available to the public before the relevant date. 3, for the purposes of subsection 1 above, a design has individual character if the overall impression it produces on the informed user differs from the overall impression produced on such a user by any design which has been made available to the public before the relevant date. Subsection 5, for the purposes of this section, so this is the validity section, a design has been made available to the public before the relevant date if, and then if you look at 5 little b, the disclosure does not fall within subsection 6 below. And then if you go to 6, and if you go to 6 paragraph C, sorry, my mistake. Yes, sorry, that's a different point. If you turn the page to subparagraph 7, in subsections 2, 3, 5, and 6 above, the relevant date means the date on which the application for the registration of the design was made or is treated by virtue of, and then it lists a number of sections, including section 14.2 of this Act as having been made. And 14.2, which is on page 562, provides the priority date details. So the whole point about this mechanism is that if you have a proper claim to priority, then the way in which the time at which you judge whether or not a design is worthy of becoming registered, so whether or not it's valid, is that you move the application date back to the priority date, because the priority date becomes the relevant date. And so what we have there is the purpose of the priority date regime is to allow you to file in one country first and then another union country. The mechanism is it gives you 6 months in which to do that under the Paris Convention, and the way in which that works within the Registered Designs Act for UK registered designs is through the sections that I've just detailed. But it's important to note that section 1 capital B is all talking about validity, and that those provisions are relevant only for the purposes of that section. So we say they do not touch upon the question of infringement. Now, if you go to page 554, we get section 3 capital C, and this touches upon when the registration takes effect, and 3 capital C subsection 3A, a design when registered shall be registered as of, in the case of an application which is treated as having been made on a particular date by 14(2) of this Act, the date on which the application is made. So the point here is that with respect to other issues, this means that the relevant date is the application date. And other issues in our submissions must include infringement matters.
So you say subsection 3C3A does not apply to infringement?
No, sorry, it does apply to infringement. So, sorry, let me just summarize it in a slightly different way. The point being is all of this mechanism, when you're claiming priority, allows a design to be judged whether or not it is valid, to move the relevant date from the application date back to the priority date. And so no intervening acts can undo the validity of the design. But for other purposes, even if you claim a priority date, then the design that you end up with, so it's the second design, the design that's been registered in the other union country, in this case the United Kingdom, the relevant date for assessing infringement, the rights arise as of the application date. Does that answer my Lord's?
I'm sorry, I'm not quite clear what you mean by the application date. Do you mean the actual application date in the particular jurisdiction, or the application which is treated as having been made because of section 14(2)?
Yeah, exactly.
Which are you talking about?
What I'm talking about is the application for the UK registered design in the UK. So that's the application date.
So the actual application.
The actual application.
Not the priority, not the one that is treated as having been made.
But moving on from that, if I have an application for a UK registered design in the UK, it's made on a certain date. That's the application date.
Right.
But if I claim priority, then by the mechanism that I've just outlined, in particular that contained in section 1 capital B, and 14 subsection 2, when you come in the UK to see whether or not that UK design is new and has individual character, the relevant date, that's the wording that's used in section 1 capital B, is the priority date.
Yes, I understand that.
So that, under section 1 capital B subsection 5,
only relevant to validity.
exactly so.
So I make an application on the 30th of June, and I claim priority back to the 1st of February, let's suppose. So the validity is to be judged as at the 1st of February.
Yes, my lord.
In the meantime, a rival has put on the market a whole series of products which are pretty much identical to the one for which I've applied. that doesn't affect validity, but you say when it comes to infringement, then all those can be taken into account.
Yes. And you see, the point is that the purpose under the Paris Convention, the express purpose, is to allow the proprietor of the earlier design the opportunity to file in another union country. And the mechanism whereby that opportunity is realised is to give them 6 months in which to do it. But they can do it much quicker if they want. So in your example, my lord, say the first design was registered on the 1st of February. If they got their act together and for whatever reason, they could register the other designs on the 2nd of February. They don't have to wait 6 months. The purpose of the priority period scheme is to allow them an opportunity to file in another country. They don't have to file anywhere else if they don't want to. But if they do wish to do so, they have a period in which to do it, and that is a maximum period of 6 months. But they don't have to wait 6 months. If they do wait 6 months, that's within their control. Now, when the Paris Convention was up and running in 1883, obviously the world moved much slower. In order to try and arrange filings in other jurisdictions, it might be quite a complicated matter. And in particular, it would probably be impossible to arrange simultaneous filings in all the jurisdictions in which one was interested on the same day at that time. You'd need massive coordination. And so that's the whole purpose of the Paris Convention, is to allow a realistic solution to allow you to register in other countries. But you don't have to wait 6 months. And if you do wait 6 months, then that's a matter within your hands, your control. And so therefore, when you look at the purpose of the Paris Convention is to, in essence, preserve validity, fine, but why should there be a spillover with respect to other matters, which are going to be assessed as of the application date in the second country?
Yeah. So if you do wait the 6 months, you're at no risk from validity, but you are at risk from infringement.
My lord, yes.
So the protection that you get by the registration is narrowed.
Well, it may be.
But that's your problem.
Yes, exactly. You've taken advantage of the purpose of the Paris Convention, and the purpose of the Paris Convention has been fully preserved and fully enacted because it allows you to maintain validity. And Section 1, capital B in the RDA is expressly for the purposes of validity, and any other consequences are at your risk. Now, the grace period is similar but different. And the point being is that with respect to a priority period, once you've got the original priority up and running, the original filing, you then have the opportunity, if you wish, to file in another country. You don't have to, but if you do, you can then claim back the priority. But with respect to a grace period, it operates in a slightly different way, and the purpose is different. Now, to see the purpose is if you go to the second supplementary bundle. This is clearly set out in the regulation, corresponding EU regulation. So, second supplementary bundle behind tab 4 and on page 23, recital 20. It is also necessary to allow the designer or his successor entitled to test the products embodied the design in the marketplace before deciding whether the protection resulting from a registered community design is desirable. To this end, it is necessary to provide that disclosure of the design by the designer or his successor entitled or abuse of things during a period of 12 months prior to the date of the filing of the application for a registered community design should not be prejudicial in assessing the novelty or the individual character of the design in question. So the point here is that for the separate concept of grace period, the purpose of the grace period is to test the market. And once having tested the market and realized that the design is successful, you can then actually make an application for, in this case, a registered community design, but the same thing applies in the UK. And so you see there that the purpose is fundamentally different from the purpose of that justifies the priority date scheme. And the mechanism is allowing for a 12-month period before the actual filing in the relevant jurisdiction, whereby you are protected from self-invalidation. So it's different from the priority point because it protects you only from self-invalidation, not from invalidation vis-a-vis third parties. Now, I need to show you how that fits into the UK scheme. So we need to go back to the Registered Design Act behind tab 18.
So just so we understand, I have a very innovative design and I want to test the market. So I put my design on the market and my competitor says, oh, that's a good idea, we'll copy that. Well, not copy it because it'll be protected by unregistered design right, but we'll do something similar. And by the time I decide, yes, it's been a great commercial success, I'd like to protect this by design, my competitor can say, can he? Well, I've been putting this thing on the market for as long as you have, and your design no longer has any novelty or even individual character. We're not taking your use into your product into account, but it's ours.
There's a number of points that
works,
you've
is it?
raised, my lord. The first point, which you yourself countered while you were posing the question, was if there's copying,
Yeah.
that doesn't help the intervener, so to speak. Partly for the reason that you've already given, that there would already be unregistered community design protection because that's an unregistered intellectual property right and arises automatically, and copying is an element of that tort. The next point is, even if they haven't copied, there will be certain provisions with respect to 7 capital B, which govern the situation of somebody who's come in innocently, so to speak.
Yeah.
So it's quite a complicated scenario you just put to me.
Right.
And I was going to try and unwrap it from the beginning going forwards. If I
Well, I'm sorry if I've
no,
sort of
not
been
at
running.
all. But it rather illustrates the way in which these matters are interlocked. Because what I've tried to show you with respect to the priority date scheme is that there's a certain purpose. And what I'm trying to show you now with respect to the grace period, there's a separate purpose. And I was just going to take you to the 1 capital B to show you the mechanism whereby that's put into place. We've already looked at this. It's behind tab 18, page 115.
Section 1B,
1 capital B, yes, my lord. Page 115.
page 551, I think.
Terribly sorry, I've misread it completely the wrong way around. My lord, you are right, of course. Sorry. The point here is we've already been through subsections 1, 2, and 3, where it points out the point about novelty and individual character. and refers it back to the relevant date. Then we go to subsection 5. For the purposes of this section, 5b, the disclosure does not fall within subsection 6 below. And then if you look at 6c, this is the thing that gives you the protection during the 12-month grace period. And so again, the 12-month grace period operates only, we say expressly only because of subsection 5, for the purposes of validity. Just in passing, but you'll keep seeing references to subsection 3, capital B. These are all to do with the fact that there's another complication. If you make an application for a design, you are allowed to amend it after you've applied, and you are allowed to divide it. And that gives rise to all sorts of other complications with respect to relevant dates. But for these purposes, you can just forget about all that. It's just when you see them, you'll see there's a whole list of them, but it doesn't matter.
The relevant date in 6C is the same as the relevant date elsewhere in 1B. So it's always the same.
Yeah.
Because it's defined by subsection 7.
Yes.
Yes.
So the long and short of that, my lord, it's a neat point because it allows me to then join what I've said in the previous 2 sections. If you have an application in the UK, everything is normally the application date, but you are allowed to claim priority. That moves the relevant date back to the priority date, and then you are allowed to claim a grace period. And so they dovetail together. And it's exactly my lord's point, because in 6C, it's the 12 months previous to the relevant date, and the relevant date might either be the application date or the priority date.
Now, you could have 18 months worth.
Yes, but the 2 periods operate for different purposes and have different effects.
Yeah.
But they only go to validity, not infringement. Now, you'll be alive to the fact there's not a lot of settled law on this, and so that's one of the reasons why we've put in both Russell Clark and David Stone's books on designs. And if I may, going to the extract from Russell Clark, which is in the authorities bundle behind tab 22, and go into paragraph 2141, which may be found on page 583. Publication of a design of a third party, even a day before the priority date or filing date, will invalidate a later design. However, as a special exception to this rule, people are allowed to publish their own designs up to 12 months without such publications invalidating the subsequent application for the registration. So what we take from that is that the authors of Russell Clark are saying that it's a special exception. So the grace period is a special exception. And so bringing all that together, we say that the priority date scheme and the grace period scheme exclude certain prior art from consideration of the design corpus when considering validity, but only validity They're expressly couched in those terms. And then there is, however, some linkage between validity and infringement. And in particular, the core test of whether something is deserving of registration, so therefore is valid, is whether or not it's new or has a different overall impression from that which has gone before. And the test with respect to infringement is the same, different or same overall impression. So the test, the core kernel of the test for validity and infringement is the same. So we don't disagree with any of the case law that you'll see where it says one might be the flip side of the other, because to that extent they are. But if you look at those cases, what they don't then take into account is that even though that's the core test, the touchstone upon which you ascertain whether or not something is valid or infringed, you have to conduct that test with the relevant design corpus. And we've already seen that for priority date and grace periods, you have a defined corpus that allows you to exclude certain things, different things for whichever whichever scheme you're looking at, be it priority period or grace period.
So
Priority
on your
date.
submission, the registered design has one overall impression when considering validity and a different overall impression when considering infringement.
Actually, it might have two overall impressions when considering validity, because there might be a different impression at the priority date and when you take into account the mechanism of the grace period.
All right, but
But otherwise your point, yes, my lord.
okay, thank you.
What I'm saying is, if you start invoking the priority date mechanism and the grace period mechanism, those are artificial ways whereby you exclude things from the design corpus when you apply the test being overall impression. But none of those exclusions apply to infringement. And we say that's clear from section 1 capital B, because all the excluding mechanisms under 1 capital B subsection 5 are for the purposes of that section only, which is validity. That's how I get to that conclusion, my lords.
So although the legal test may be the same,
Yes.
the background against which the legal test is applied differs or may differ as between validity on the one hand and infringement on the other.
Yes, my lord, exactly so. But once you've got that underneath your belt, I'm sorry it's taken a bit of time, but once you get that underneath your belt, then pretty much everything else falls into place. That's why I was trying to lay it out in this way neutrally to start with. So, I mean, that's really it. So, moving on to the first ground of appeal, which is the point that's raised within the judgment of paragraph 64. And I can now move along a lot quicker, if you see what I mean, having laid all that groundwork, is that the grace period is to test the market. That's the purpose, that's the rationale of it. But once you've tested the market and seen whether or not the product is worthy of going to the trouble and expense, even if the expense is low, of seeking a registered protection, then you've fulfilled and gained the benefit of the grace period mechanism. And so therefore, any delay after that is at your own risk, we say. And that if you have tested the market, and if you have ascertained that the product is successful, then you've reaped the full benefit of the express purpose of the grace period. You don't need to hang around for longer. And you can then go off and seek your registration. So once tested, once realised it's a success, the purpose of the grace period is fulfilled and you can then go and seek registration. And the point being is if you hang around, what you're then doing is the product is now successful, assuming you then go off and register it, is you're clearly, even if it weren't very successful, influencing the mind of the informed user. Now, you all know the informed user is somebody who is not just a standard user, but knows more about the market than otherwise, hence informed. And this is captured in, let me just find the relevant quote. It's just a second. I'm terribly sorry, I have now. It's the Procter & Gamble case in the Court of Appeal, which is the authorities bundle behind tab 3. And it's paragraph 35, and in particular 35 subsection, little Roman 3, which is on page 73 of the bundle. So authorities bundle tab 3, page 73. Little Roman 3 and little Roman 4. Next is not a proposition of law, but a statement about the way, and thus the notional informed user, perceive things. It is simply that if a new design is markedly different from anything that has gone before, it's likely to have a greater overall visual impact than if it is surrounded by kindred prior art. It follows that the overall impression created by such a design will be more significant, and the room for differences which do not create a substantially different overall impression is greater. So protection for a strikingly novel product will be correspondingly greater for a product which is incrementally different, than for a product which is incrementally different from the prior art, though different enough to have its own individual character and thus be validly registered. Little Roman 4, on the other hand, it does not follow in the case of a markedly new design, or indeed any design, that it is sufficient to ask, is the alleged infringement closer to the registered design or the prior art? If the former infringement, if the latter not, the test remains, is the overall impression different?
So what are you getting from this?
So what I'm getting from this is the point.
That putting your product on the market during the grace period will influence
Perception of
the perception of the informed user.
Yeah, I mean, it's the first 2 lines, but to be fair, I read out the whole thing.
But I'm a little puzzled, Mr. Edenborough. Is it not implicit in Lord Justice Jacobs' reasoning in this passage that the individual character and overall impression created by the registered design is the same for validity and infringement?
Well, I mean, the answer to that is no, I don't think it is implicit. Because basically, he hasn't undergone the analysis that I have just taken you through, which shows that clearly...
That seems to mean it is implicit, but it is wrong.
Well, my lord, yeah.
I mean, it is implicit in the reasoning, isn't it? But you're saying it's wrong.
Yes, for the reason that I put forward.
Well, it's wrong in a case in which the priority period and or the grace period are relevant.
My lord, yes.
Otherwise, it may well be right.
Well, yes, there's going to be cases where it doesn't matter.
Yeah.
You see, if there were no grace period, and for example, there's no grace period with respect to trademarks, and there's no grace period with respect to patents in this jurisdiction, there is a grace period with respect to patents in the US, then if you want to get a registration and not destroy the validity or the potential validity of the forthcoming registered right, you have to file there and then. And so therefore, there could be no effect upon the perception of the relevant public, the informed user in this particular case. But the grace period allows you, through a special mechanism, to test the market, and then it excludes from the issue of validity your own actions. But why should it affect the effect upon third parties for other purposes?
So grace period is a bit of a trap then, isn't it?
Yes, potentially. It has a particular purpose, but there are consequences to taking advantage of that particular purpose. And I think that's perfectly reasonable. And also the way in which the legislation, in particular section 1 capital B, is crafted. It's clearly crafted that the effect of both the priority date regime and the grace period regime appertain only to the question of validity. I mean, that's expressly the point.
I've understood
You've got
that.
that.
I've understood
Yeah.
that.
Sorry, I'm just and actually, he said that there is a comment to this effect in David Stone's book, which you'll find in the authorities bundle behind tab 21. And behind tab 21 on page, oh, that's odd, 185 of the book. Doesn't seem to be numbered.
It's invisible.
Oh, it's invisible, sorry. Yes, my learned friend has said. It's 572. You can just discern it in the bottom right-hand corner. Thank you. But it's 185 of the book, the internal numbering. And it's paragraph 1099. The designer is given a grace period of 12 months in which to disclose his or her design and attempt to commercialize it. During that time, the designer's disclosure does not count as prior disclosure for the purposes of the validity of any later registered community design registration. And so the point then is that the way in which I say that manifests itself in this case,
What's the grace period trap to which you?
that is completely different.
That's different, is it? Right.
Just, I can. Yes. It's where you have tried to take advantage of the grace period. Another party has come in. This other party, have sought to seek a registration. You are now trying to undo their registration. You can't because of the grace period. And the way in which you should deal with it is to challenge the ownership of the other party's registered design. Not trying to invalidate it, you should try and challenge the ownership.
So my use of my product during the grace period is not only irrelevant to the validity of my design, it's irrelevant to the validity of my rival's design. Is that
Well,
what it
I
comes
mean,
to?
it's a bit more complicated than that. Sorry, I was trying to answer it very quickly.
Right, never mind.
No, it is actually irrelevant for these purposes.
All right.
But the long and short of it is that the trap is you need to challenge the ownership, not seek to invalidate. Right, so the consequence of all that is I say that when you're looking at infringement, and I say the relevant date for infringement is the application date in this country, that the relevant corpus is everything. Because you've not artificially cut down the corpus through the mechanism of priority date or grace period, because we're not looking at some diminished corpus for the purposes of validity, we're just looking at the corpus as perceived by the informed user at the application date. And the easiest way of seeing the effect of this is if you go to the core bundle, behind tab 8, and if you go to page 88, this is an annex to my learned friend skeleton, but it came from our side at trial. But what my learned friend has done is on pages 88 and 89, he's colour-coded the relevant prior art that we're particularly talking about. Page 88, can you see in red the M&S snow globe?
Yes.
So that's in on any view. Then if you turn the page to 89, you get 3 entries that are orange. And on the analysis that I'm putting forward to you, those come in.
Yes.
And you can see those. They're in the supplementary bundle. Behind tab 2. At pages 64 and 65. And for your note, the one that's in on any account is at page 62. And so once you have those in the frame, we say the perception of the informed user is altered in such a way that the allegedly infringing products do not infringe. Now, my lords, I was going to go to ground 2 because the way in which this dovetails with ground 1 is as follows. On ground 1, if I'm right, then when you consider infringement, you do not exclude anything. So there's 0 excluded designs. But then on ground 2, depending where you alight on ground 2, you will exclude one design, which is a design that is either identical or differs only in immaterial details, or you will exclude a few designs, namely those that have the same overall impression, or you will exclude many designs, which is basically everything. And what happened here is the judge decided that you exclude everything that was put on the market by the person that eventually sought the registered design protection or a successor in title. We say that last position cannot be right. And if you are against me on ground 1, I say that the way in which you should decide ground 2 is that you only exclude one design, which is the thing that is identical to or differs only in immaterial details from the registered design that was eventually sought. So, in summary, it's a 0, 1, few, many cascade. 0 is ground 1. 1, few, many are 3 aspects of ground 2.
What is an immaterial detail?
If
If it is not one that changes the overall impression, it's you
I was
suggesting
going-
it's something smaller than that.
It is something, the reason I'm using those terms is because that's what's contained within the legislation. We say it's something that you pretty much wouldn't notice, but it's not exactly the same. And the reason why that's probably relevant is because, remember, when I was talking about priority date and claiming priority date, you needed identicality. If you saw the quote that I said,
Yeah.
gave you from Samson, paragraph 33. If you do not have identicality, you can't claim priority properly. That's it. But here there's a little bit of wiggle room. So it can be identical or differ only in immaterial details. Let me make good that point about immaterial.
So, I mean, if it differs only in immaterial details, it will still create the same impression, overall impression.
Yes. My lord, to make good that immaterial details point, if you go to the Registered Designs Act behind tab 18, the authoritative bundle, again I'm back to section 1 capital B, section 1 capital B subsection 2. For the purposes of subsection 1 above, a design is new if no identical design or no design whose features differ only in immaterial details. So it's been considered in the same category as identicality with respect to novelty. Tab 18, page 551, subsection 1, capital B, subsection 2.
Yeah.
Now, this is the bit that's created some confusion within the case law, so to speak. If we go to David Stone's book behind tab 21, and if you go to page 187 of the internal numbering, which is page 574 of the authorities bundle, and if I may take your attention to paragraph 10, 110, Now, this is in the context of the regulation, obviously. Reading the words of Article 7.2b, there is some unclarity concerning whether the protection of the grace period applies if the latter application is for a design that differs from the design originally disclosed. That's an understatement. It then goes on to, in paragraph 10.111, if you look at the last sentence of that paragraph, a purposeless reading of Article 7.2 of the regulation would therefore allow the protection of the grace period not only for prior disclosures of identical designs, but also designs that create the same overall impression on the informed user. So there, Mr. Stone is opting for the middle ground that I've labelled few. But he then says in paragraph 10.112, the office, that's the EU IPO, has adopted this approach. So that seems to support what he's just said above. He then quotes from a case to which I'm going to take you. This is the Apple case in the EU IPO. And then summarising that in paragraph 10.113, in short, the position appears to be that any prior disclosure by the holder in the previous 12 months will fall within the grace period. So having said one thing in paragraph 10.111, he now seems to say something.
He's plainly meaning any prior disclosure of a design or one that creates the same overall impression. He's plainly not intending to say something quite radically different when he's purporting to summarise what he's already said in 1112.
My lord, yes. But the point being is that the judge has relied upon this to reach the conclusion that it is any design.
I'm not sure that Mr. Campbell is wholehearted in his support for the judge's wide
No, but
interpretation.
I'm now going to take you to the case, and I rely upon the way in which they've reasoned the case to try and show you that actually the EU IPO were advocating that it should be a narrow construction. It should only be the one design which is identical or differs only in immaterial details. And it's not even the second way of looking at it, which is those that differ only in immaterial, that create the same overall impression. Now, the EU IPO case may be found in the authorities bundle behind tab 7. And the paragraph that's quoted within Mr. Stone's book, paragraph 44, is on page 172 of the authorities bundle. Now, in the report, at paragraph 44, it says, regarding the designs D1, D15, and D24. Now, I need to stop there because that's wrong. D15 should actually be D16. There's an error that the EU IPO created there. Now, to make good on that, this, of course, as you know, is all discussion Article 7.2. If you go back to page 166 of the authorities bundle, this is where they're setting out the matter. Paragraph 10 says the applicants further hold that designs D1, D16 and D24 are not the designs for which protection is sought pursuant to Article 7.2. That is correct. D16 in that paragraph is correct. And remember, this is all to do with excluding, sorry.
Well, we can see there's an inconsistency, and the obvious explanation is that there's a typographical error. How do we know that 16 is correct and 15 is wrong? Rather than vice versa.
No, I'm just going to deal with that, my lord. If you go to paragraph 38, paragraph 170 of the authorities bundle, this is under the disclosure part of the judgment. This is where it's talking about certain designs, including D15. And if you look on page 171 towards the end of paragraph 38, as the disclosure of the phone was proved by the supplementary evidence, the office considers D15 to be relevant prior art in the assessment of novelty and individual character. So D15 has been considered to be relevant prior art. But the whole purpose of paragraph 44 is to see what can be excluded under Article 7.2. You can also see from paragraph 38 that a D15 talks about the Motorola ROKRE6 phone. And if you go to page 161, which conveniently talks about D15 and D16, you can see that D15 is with respect to the Motorola ROKRE6 phone. So my Lord Justice Arnold, that's why I say that in paragraph 44, where it says D15 is wrong, it should be D16. They've just muddled up that. And the way in which I've proposed is consistent with the rest of the judgment. Now you have to look at what has been excluded by D1, D16 and D24. If you go to page 154, paragraph 1, that's the registered community design that's in question. So it looks like a picture of the front of an iPhone. The next page, 155, paragraph 4, the first bullet point defines D1, and it says it contains images of an iPhone with a graphic user interface. Page 161 of the authorities bundle, the second bullet point defines D16.
Sorry, 161.
Correct, my lord. This is the page that defines both D15 and D16. The second bullet point, still image of a video posted on the website, basically of the iPhone interface. And then if you go to page 165 of the authorities bundle, it's the very last bullet point under what is paragraph 4. You can see that D24 is an image of an iPhone graphic interface. So that's all consistent with things that potentially could be excluded under Article 7.2, as discussed in paragraph 10 of the judgment. And then, if you go all the way back to paragraph 44, which is on page 172, having in my submissions established that it should read D1, D16, D24, the discussion then is about D1. And what it says about that, and this is about halfway down, the applicants, however, argue that the disclosed design is not the same design for which protection is sought, because in the disclosed interface, one icon is missing and some others are in a different order from those in the graphic interface registered as the community design. So if you go back and see what the community design is on page 154, it's talking about something that's disclosed in D1 that is the same as that, save for the fact that an icon is missing or some of the icons are in a different order.
Well, it's both. It's both. Missing and some.
Sorry.
Well, hang on a minute. Go back to 44.
My lord.
So the applicants, that's Samsung, are saying it's not the same design.
Yep.
And the holder, that is Apple, says that the exception applies not only to the registered design, but also designs disclosed by various people in relation to designs which can constitute an obstacle to the novelty or individual character of the RCD. Now, as you've shown us, novelty talks about immaterial details, and individual character talks about overall impression.
Yes.
And then the decision goes on, the office agrees with the holder. So that's the middle ground, isn't it?
Yes.
That of the three, of the cascade.
Yes, my lord. But I'm going, exactly so. That's the way it's phrased at that. But if you actually look at the decision, I say that what was disclosed in D1 falls within the very first thing. It's either identical or only differed in immaterial details. Because if you look at the registered community design on page 154.
Well, that may be so, but on the legal point, which is argued in paragraph
Yes.
44, the decision seems to be, they agree with the holder, so designs which can constitute an obstacle to novelty or individual character are excluded.
My lord, yes.
Yeah.
But then what I'm saying is the first point is if you look on the facts, it seems to accord with things that are either identical or differ only in immaterial details.
Well,
That's quite a common law way of analysing.
Yes, but I was then going,
Also, why is that right? Because we read that the differences are, first of all, one icon missing. Secondly, others, we don't know how many others, are in a different order from those in the graphical interface.
yes,
So you assert that
Yes.
that's immaterial
yes. But I'm going to,
differences, but there's no decision to that effect.
no, but I'm going to develop why I say my assertion is correct, my lord. The reason why I then say it is correct is because if you read down paragraph 44 to the end, the purpose of the provision is to allow the holder of the design to disclose it from a 12-month period before the date. And so in the facts of this case, I'm asserting that what was disclosed in D1 is either identical, probably not, or differs only in immaterial details. And the way in which the EUIPO then decided it, they seem to, in their conclusion with respect to D1, say that it, the design, had been disclosed.
You're putting a lot of weight on one word,
Yes.
ignoring the fact that the very same sentence goes on to say, on which the design has to comply with the conditions of novelty and individual character.
Yes.
And if you read it as being restricted to the same design, the reference to individual character makes no sense.
Well, it does, because the point being is that's just the way in which they're phrasing it. That if it really fell within the second point, they wouldn't say that there's a single design, they would say that that which is being disclosed is different from the registered community design, but differed only in having the same overall impression. The point being is, my lord, is I say that favours that it should only be one. If I'm wrong on that, it can only go to allowing things that are either identical with immaterial differences or things that create the same overall.
Yeah. So you say it provides no support at all for the broadest of the three interpretations.
Exactly. My preferred position is the narrowest.
But if can we just go forward to paragraph 63?
Of the judgment.
Yeah,
Yeah.
where the office is considering individual character. And it says it's got the design has individual character over submitted designs D2 to D11, D13 to 15, and D17 to 23. If
sorry.
you're right, wouldn't D16 feature in that?
Sorry, my lord, I was in the wrong judgment.
Paragraph 63.
Yeah.
They're looking at individual character, and they say that design has individual character over designs D2 to D11, D13 to 15, and D17 to 23. If you're right, shouldn't D16 have been considered there at that point in the decision? Because you've shown us that in paragraph 44 there's a misprint.
I think this is consistent with the misprint, because what the reasoning is D1, D16 and D24 are excluded from consideration.
Yeah. That's why I needed to go through the boring bit that I think there is a misprint.
Yeah, I mean that's very helpful, because otherwise it gets very confusing. But as far as the point of law is concerned, it doesn't matter.
Exactly. And you've got my point on that. I say it's the narrowest.
Yeah.
I say it certainly isn't the widest, but you could read it in the middle.
Yeah.
And my lord, you'll see the consequences of this because we've set it out in our skeleton argument at paragraph 35, that if my preferred position is right, you only exclude one. You can still take into account the three, if you go back to the core bundle tab 8, page 89, this is the table, my lords.
Yeah.
And we're looking on the second page, and we're looking in particular at the orange designs. With my preferred position, I can include all three.
Mm-hmm.
With the middle ground, what you do is you exclude wait a minute, just a sec. 63. The one on page supplementary bundle tab 2, page 65, but the one on the right.
So we go to supplementary bundle to
Tab
62.
Page 65. I'm sorry, I got that the wrong way around. You would then exclude the one on the left, the Clementine example. But you'd still consider, for the purposes of infringement, the one on the right, which is the rhubarb example. But my lords, just in case I've muddled myself in my oral submissions to you, that is all definitely set out in the skeleton argument, so that there's no doubt about.
Can you just help me on this? The one on the left,
Yeah.
how does it actually differ from the registered design?
Oh, well,
It seems to be identical.
no, it's not, my lord. It's got the watch strap, for example. You know, the thing over the
I
cork.
see, right, yes. But apart from the watch strap, is there another difference?
Well, yes, my lord, there are 4 registered designs in issue, and the latter 2, that's 82 and 84, are dark.
Right. There's a dark background here.
Yes, my lord,
Depends how you interpret the registered design. Yeah. But yes, all right, I understand. Thank you.
I was going to leave that poison chalice to my learned junior, my lord. I've had so many poison chalices given to me over the years. So, my lord, anyway, that's the point about, so to speak, if you settle on the middle ground, the one on the left goes. So, my lord, that deals with grounds 2 and 3. You'll be pleased to know the grounds 3 and 4 are shorter.
You mean 1 and 2 you've dealt with, so now,
Sorry,
now
my
you're
lord.
dealing with 3 and 4. Yeah.
3 and 4, and the whole point here is that we say the relevant date for assessing infringement is the application date. Now, there's 2 ways of getting to that. The first of which is that you say either that is how the whole case was pleaded, argued, and presented before the judge, and everybody thought that was the right date. No submissions were made for any other date, but the judge decided in his judgment to use the priority date. We say you can't do that.
And it's not necessarily a defence, but that's actually been done in patent cases, because I've certainly had experience of patent cases where everybody's argued on the basis of the application date being the right date for interpretation of the claim, but the judge has proceeded on the basis that the correct date is the priority.
Thought differently, my lord. That's why you all know the case law. I was only going to refer to it without taking you to it in detail. It's a point for you. We say basically it's a step too far when you consider the issue of an inquisitorial as opposed to an adversarial system.
There's a striking example quite recently in the Supreme Court where a question arose, what was the meaning of a clause in a lease about a service charge? The Supreme Court adopted an interpretation for which neither side had argued. Nobody had ever mentioned it. It provoked a dissent from Lord Briggs on precisely that basis, but the majority said, well, there we are.
My lord,
That's
there is
the
plenty
grass.
of case law on this. I mean, in the IP world, IP translator is the absolute classic, because the Court of Justice, an 11 panel, 13 panel, it was the Grand Chamber, handed down a decision on question 3 that had never been canvassed by any of the parties or any of the 11 interveners. So this happens. I say it shouldn't happen, but that's as far.
On a question of law, the court has to give what he thinks is the right answer, isn't it?
Well, there's another point here. May I just give you the reference for crossing the line? And that is the Satcham case, paragraph 37.
But I mean, I can see that you may say, well, it's unfair for the judge to dream up a point of his own and not give me a chance to comment on it. But you've got a chance now.
Yes, but the point is that in this case, because everybody thought the relevant date was the application date, priority never came into question. It never rose at all. And if priority had risen its head, then it may well be that the case would have taken a different course. Because remember, this was, the application date was put forward from the very beginning. And if priority had been raised, then there may, I only put it as speculation because we don't know what will happen, have done different things with respect to challenging the priority. So the whole course of the trial might have changed because
Can you assist me on that? Because I'm a bit puzzled at first blush by that submission. Because, again, if one analogizes with patents, in patents, the burden is on the party challenging priority to plead and
Yes,
prove
yes.
that the priority claim is.
but the point is priority was never.
Sorry, I'm
Sorry.
not to prove it, but to raise the challenge.
No,
Sorry,
I
the way it works is you assume the priority is a valid claim unless and until the party attacking it puts it in issue, at which point the legal burden is on the proprietor to justify.
Yes, but my lord, the way in which this arose is that the relevant date was always thought, from infringement point of view, to be the application date. And so priority never rose at all. So it was not in issue because there was no need to put it in issue. So it's a
Well,
slightly...
you're going to have to show us the pleadings because, as I say, in the patent context, this would be an issue to be raised on the pleadings.
Yes, well,
If there was a challenge to priority date.
If I may say so, Mr. Edenborough, your skeleton argument doesn't give any hint that if priority had been an issue, then the trial might have taken a different course. It just says this judge was wrong to do it.
well, yes, my lord, this is not my main point.
Right.
So,
I mean, if there was a serious point here, I mean, if you really are saying, you know, we would have called different evidence, or we would have examined the EU filings more closely, or
Yeah.
something, then that may give legs to your point.
yes, well,
It's mere speculation.
it is mere speculation, but unfortunately it also gained some legs when my Lord Justice Arnold raised the points on the respondent's notice with respect to other issues with respect to the registered community design. Because then if you start looking into that, there seems to be some scope for, it's all to go with the description point.
Well,
my lord, it's
we'll
not
get
my
onto
main
that
point.
in due course.
Exactly, it's not my main
I'm not sure
point.
that's necessarily correct, but we'll see.
So I'm not going to press it hard. I've raised it, and that's what I was going to say.
All right.
But the real point that I have here is that it's the right date.
Yes.
And the reason why I say it's the right date is because when we've been looking at other dates for the purposes of invalidity, there's been special provisions with respect to the priority claim and or the grace period. And all of those have been framed with respect to the issues of validity.
That goes back to your preamble.
Exactly.
Yeah.
So we say when you're assessing infringement, the relevant date is the date of application. And there's the judgment in, let me get the right authorities. This is the Dyson case at first instance, behind tab 4 of the authorities, page 106. Paragraph 44. And this was whether the relevant date is the date of registration of the registered design, and the trial judge decided that was the relevant date.
Yes, but the alternative date that was in issue was the date of the alleged infringement.
Yes.
So far as I can recall, as far as the judgment goes, there's nothing about priority.
No. So dealing with that point, this was a decision between date of infringement and registration application date, decides that the application date is the relevant date. In this case, we have a difference between registration date, application date, and the priority date.
What Dyson decides is that it's the date of the registered design, but you say that means the application date.
Yeah.
Not the date of registration.
Correct. Yes. Date of registration, the actual date of registration is then referred back to.
And that is presumably because the legislation says that it should be registered as of a particular date.
Yeah. My lord, if you
Why
just.
doesn't section 14.2 do the same thing?
Just to explain my lord's point, if you look at paragraph 2 of the judgment, what it says is the registered design was applied for on December 7th, 1994, and that is its date of registration.
Same date. Yes.
But then my lord asks a question of you.
And I think the answer to that is in the Registered Designs Act 49, section 3, capital C, which may be found behind tab 18 on page 554. So 3, capital C, subsection 3A.
As of the date.
Yeah. So we say everything refers back to the application date. We say the reasoning in paragraph 44 in Dyson is apposite to support that as opposed to the priority date. Then you have this point that because once the application for a design has been successful and it is registered, the rights arise as of that application date. You can then sue. But you could never sue for an event that occurred before the application date, and in particular, you could never sue for an event that occurred around the priority date. And so we say that that would be just wholly unrealistic to assess infringement at a point in historical time where you could never get an infringement action up and running.
Well, are you assessing infringement? You're assessing the overall impression, which is part of infringement. But in order to infringe, you've got to be doing something that's prohibited by section 7, haven't you? So why do you say you are assessing infringement at an earlier date? You are assessing overall impression,
But yes,
which is on the way to infringement. Obviously,
yes.
it's an ingredient of infringement, but it's not the whole thing.
The test for infringement is the overall impression test, but the context.
Well, yes, but the test for infringement is doing something
Yes,
which
yes.
is prohibited by section 7,
Yes,
and that brings in the question: is what you are doing being done in relation to something which produces a different overall impression?
yes. In the context of assessing the design corpus at the application date. And we say it's appropriate when you're considering infringement to assess the design corpus at that date. It's wholly artificial to assess the design corpus at an earlier date, for example, the priority date. So my main point on this, regardless of whether or not the judge did something which he could or could not do, we say that the judge was wrong. The relevant date is the application date, not the priority date, when you take into account the corpus, and the corpus should be everything subject to my grounds 1 and 2.
Yeah.
and this is because, harking back to the things I've said at the very beginning, validity is similar to but different from infringement. Might be have the same core test, but it's the context in which you assess that test. Ground 5 is basically, because of all the foregoing, you should revisit the matter and decide in my favour, to put it bluntly, but you have the points.
Yes.
My lords, if there are any further questions, not, might
very
I
much,
give
Mr.
way to my learned junior?
Yes, Mr. Elias.
My lord. My lord, if I might just start by taking your lordships to the relevant bits of the pleading in relation to the filing date, since it's a question expressly asked by my lord, Mr. Justice, Lord Justice Arnold. We find this in the core bundle at tab 17 is the amended particulars of claim. You'll see paragraph 3 sets out the claimant's registered designs, and then they are annexed in the usual way, but the particulars set out over the page,
Yeah.
you'll see it gives the design number, filing date, description, illustration for the 5 designs. That was responded to in the defence at tab 18, page 147. Paragraph 15 of the amended defence.
Yes.
And you'll see there that it's raised at paragraph 15 prior to the 29th of April 2021, being the filing date of each of the claimant's registered designs. The various features identified below were common in the design corpus. So we have taken the application date and pleaded the design corpus in relation to it, which is how we understood the case to be put. The priority date was, of course, 15th of December the previous year. In the reply, tab 19, no issue is taken with the pleading at paragraph 15. We see that at paragraph 9 of the reply on page 158. They obviously deny that the design corpus shows the relevant features that we rely upon, but they don't take an issue with the date. And then at paragraph 10, they in fact refer to some other products which they complain and say these were launched after the filing date of the registered designs and are therefore not relevant designs in any event. So that further emphasises the point that both parties at this point are proceeding on the basis that the application date, filing date, is the relevant date. If I could please just take you then to the supplemental bundle and the CMC order, and that's at tab 3. And in the normal way in IPEC, the CMC order has, at page 126 of the bundle, a list of issues. And you see point 2 there. The issue is the state of the design corpus as at 29th of April 2021, which is the application date. That's all I wanted to show you in relation to how the case was put at trial. But in my submission, it shows that the application date was the date on which all parties proceeded to analyse the case, and then, in fact, it formed part of the court order in that it was part of one of the list of issues, made specific reference to that date as being the relevant date. Moving on then to ground 6. Ground 6 relates to what we say is the dark background, or the dark colour of the liquid, or the dark coloured glass bottle in designs 82 and 84. And I would like to start by taking you to how this was pleaded. Again, I think it would be a useful exercise. So if you could please take the core bundle at page 17, tab 17, page 135. 136, you will see as well.
Just before we pause, we move on. You'll notice that in paragraph 3, line 2, it said that the registered designs comprise 4, quote, light-up gin bottle designs. So that's how they are described.
Yes, and the same words appear on the following page as well as description in the table.
Indeed, and the state of the register has changed, as I'm sure you're aware. That was accurate as at that time, as we see from the supplemental bundle. When you look at the register now, this is something different.
So I understand. Is my lord asking me a question specifically about this?
Well, I mean, we need to get onto that issue at some point. I mean, it doesn't have to be now, but we will have to
Absolutely,
come
my
back.
lord. I will address it in due course when dealing with the points raised in the respondent's notice. But at the moment, I was just looking at ground 6 and the point about the dark.
Yeah,
tint.
but it might be worth just picking up that in the defence, paragraph 4, it's admitted that each of the designs is described as a quote light up gin bottle, but it's denied that any of them shows an integral light source.
Yes, my
Your
lord.
client's position was none of them had a lighting,
None of them had an
and
integral.
the judge came down with a halfway house.
Exactly so. So the judge found, if one looks back at page 136, the judge found, of course, that the images which appear dark had the light source, and the images that appear light did not. So moving on the point about how the darkness was pleaded, if you turn please to page 137 in paragraph 5, this is the claimant setting out the particulars of its registered designs. And you look at paragraph 5a, it says UK 78 protects the appearance of the whole or a part of a light up gin bottle, in quotes, resulting from the features shown in UK 78 in particular. And then I'm turning here to point 2, an integrated light feature incorporated into the base of the bottle and the visual impact of the illumination and darkness. And that pleading is repeated in respect of all 4 designs. You see that at subparagraphs B, C, and D. In the amended defence, and that's at tab 18, page 145, paragraph 7.3, you will see that we pleaded that we thought this wasn't a very clear pleading. The allegation that the visual impact of the illumination darkness is a feature of the design is unclear and appears to rely on differences between UK 78 and 82. It seemed to plead as a feature of each design the difference between it and some other design. We say to the extent it's understood it's denied, both images and the registration are brightly lit. And while we are in the amended defence, could we also please turn to paragraph 25, which is at page 150.
Your para 7.3.
Yes.
So the impact the visual impact of the illumination and darkness as a feature is unclear, and that's in quotation marks. So where does that appear in the amended particulars of claim?
My lord, that is the point we just looked at in paragraph 5a little 2.
Oh, I see. Yes, thank you.
I'm simply quoting the claimant's own pleading back at them
yes,
to say.
yes, thank you. Yeah.
So paragraph 25 of the amended defence, you will see that here we set out what the defendant, Aldi, said were the most notable features of various designs. Paragraph 25, we address UK 82, which is the first of the dark coloured images. And the very first point we make about it, which we say is a relevant feature of this design, is the striking dark tint of the bottle and or the contents of the bottle and a white cork. And then paragraph 32 and 33, that's on page 152 of this amended defence. So paragraph 32 is pleading to 6b little 7, and that is the standard form pleading that the allegedly infringing items do not produce a different overall impression on the informed user. And the pleading denies this and says the informed user would identify the following differences between UK 78 and the defendant's gold flake clementine liqueur bottle. That's 32. And at 33, we say the same differences apply as between the defendant's clementine bottle and UK 82 and 84. Those are the two dark registrations, if I can call them that. And in addition, the defendant's clementine bottle and or contents is clear. The bottle and or contents of UK 82 and 84 possesses a strikingly dark tint. And I'm showing you this point simply to make the point that we not only raised the question of whether it had a dark tint, but we expressly said this is the most prominent feature of these two designs, is this dark tint. And we say this is a reason why the informed user would not find that the Aldi product made the same overall impression as the designs 82 and 84. So I'm just showing you that it is prominently and squarely in the pleadings. If we could then please turn to the reply at tab 19. Paragraph 5b, that's on page 157. (5b) 157 says, in respect of paragraph 7.3, that was our pleading that the description of the visual impact of the lightness and dark wasn't clear. It's admitted that both images in registration 78 are brightly lit. The reference to the visual impact of the illumination and darkness is a reference to the visual impact of the background on the design. One might pause there to say the word on is possibly ambiguous as to whether it forms part of the design or not. The background in UK 78 is brightly lit and the background in UK 82 is dark. As the defence notes at paragraph 9.1, the particulars in respect of UK 78 and 82 are identical, with the language referring to the visual impact of the differently illuminated backgrounds. For the avoidance of any doubt, the claimant relies on the visual impact of the illumination in respect of UK 78 and the visual impact of the darkness in respect of UK 82. 2 points come out of this. One is that at this stage, the only difference between UK 78 and UK 82, as the claimant put it, was this dark coloration, which it describes as background. The second point is that the claimant says it expressly relies upon the background at this paragraph. And in my submission, if the claimant is relying on the background, then it demonstrates that it is a feature of the design. And indeed, on the claimant's case at that point, it must have been a feature of the design, because otherwise the claimant thought there was no difference between the two designs. That's how it's put in the pleadings. If I can then move to the judgment, if I can ask you first to take the supplemental bundle and look at the trial skeletons. So first of all, Aldi's trial skeleton, which is supplemental bundle, page 10. Sorry, tab 10, page 262.
Tab 10, page
262 is
262, yeah.
the skeleton. 264 is the part I'm taking your lordships to. Paragraph 8 from page 264. I highlighted here, there's a point about the proper construction of the registered designs, and in particular whether they show an integrated light source in the base of the bottle as claimed, and whether UK 82 and 84 show a dark coloured bottle and or liquid. And the very similar point is repeated at the end of paragraph 10, if you just look down the page. Saying the photographs show a dark coloured bottle and or liquid.
Yeah.
Now, in the claimant skeleton argument for trial, which is at tab 9, and in particular at paragraph 16 onwards on page 240, you will see that paragraph 16, the claimant said, remarkably, there is an issue on the pleadings as to what they show. And looking through what follows, the only issue raised by Aldi is whether or not all the designs have an integrated light source or not. So at paragraph 20, for example, we can see it says Aldi denies that any of the registered designs show an integral light source. So that feature is addressed, and paragraph 21 is the goes to the light up gin bottle point, showing that the claimant did not at all rely on it at trial. Paragraph 22 again addresses the integral light feature and just says in passing the bottles are shown against a light and dark background respectively. Turn the page to paragraph 23. Pausing here, how else could one show an integrated light feature in a bottle, save for showing it illuminated against a light and dark background in several orientations? So that is Aldi's trial skeleton. It only identifies the one point of dispute and says in passing that this is only, the images simply show a different coloured background. If I could please then return you to the judgment in the core bundle at tab 11. And the relevant section on interpretation of the registered designs is at tab 9. And as I will show you in a moment, in my submission, what's gone wrong here is that the judge has followed Marks and Spencer's skeleton at trial, the claimant skeleton at trial, and has addressed the point as to whether or not there is an integrated light, and has followed the claimant's lead in assuming that there is a dark-coloured and light-coloured background, but has not actually analysed that particular point. So if we look at paragraph 9 of the judgment onwards at page 101, interpretation of the registered designs, there is, first of all, an extract from Magmatic. None of the law in this respect was in dispute. But I would just like to show you one point from Magmatic, if I may, which in fact is quoting Lord Justice Kitchen. If we could look at the authorities bundle, tab 9, page 237. And paragraph 30, the extract from which appears in the judgment and indeed in our skeleton, but because the following few paragraphs just expand upon that a little, it may be helpful. So paragraph 30, it says, about 5 lines down, it is of course up to an applicant as to what features he includes in his design application. He can choose whether to include lines, contours, colours, shape, texture, materials, or ornamentation. At the bottom of the page, there is an extract from an article by Dr. Schlurtelberg, which explains where an applicant wishes to exclude features which are shown in the representation for explanatory purposes only, but do not form part of the claim design, he may disclaim those auxiliary features by depicting them in broken lines for drawings, or by means of colouring them for black and white drawings or photos, or encircling them for any drawing or photo. And then further down in paragraph 32, about 6 lines down, it says, more broadly, it is for an applicant to make clear what is included and what is excluded in a registered design, and he has wide freedom as to the means he uses. This, of course, concerned a community registered design. But of course, the potential for disclaimer exists under the UK Acts and Rules just the same. It's at Rule 6 of the Registered Designs Rules. And so the onus is on the applicant to show, the starting point is to say the picture shows what forms part of the registered design.
Can I ask this, what is it? What is a dark background? Do you mean the glass is coloured or the contents of the bottle are coloured? Or what is a dark
The
background?
difference between us, my lord, is that as I understand Marks and Spencer's position, they are saying that it just so happens that the bottle has been photographed against different coloured backgrounds, and that should simply be ignored. They say it forms no part of the registered design. What we say is that it appears in the image, and therefore the starting point is that it forms part of the registered design. We say that from the image, it appears that either the liquid is dark coloured, or maybe the bottle is tinted, or possibly both. But we certainly say,
as you say, this has got nothing to do with the principle of law to which you've just drawn our attention, which is about how you exclude matters by dotted lines and so on. It's a question of interpretation of the image. I mean, what's really going on here, we might as well get it out in the open, is that all 4 registrations are for the same product. They are photographs taken under different conditions. So we've got photographs with the gold leaves shaken up, photographs with the gold leaves settled on the bottom, and so on. But Marks and Spencer chose, rather than trying the course of putting all representations into one registration, to separate them out. And you say they're stuck with that.
well, my lord,
I understand that point. So you consider each registration on its own terms, and you ignore for each registration the other registrations.
yes.
But you're still left with the task of interpreting the image you are shown, which you know is a photograph.
Absolutely. And my lord, so with respect, the part of the law I took you to is relevant because it emphasises, first of all, that the image is the most important part. I think there's no dispute about any of this. Secondly, that where an applicant chooses to include colour as part of that image, then colour is claimed as part of the design. And thirdly,
Sure, but we're concerned here with colour photographs. I don't understand what you're getting at.
and thirdly, that it is open to the applicant who can choose what to put in. If something is not being relied upon, as appears to be happening in this case, Marks and Spencer are saying we should just ignore the background. If it's not relied upon, it's up to the applicant to disclaim it or make it clear in some way that it does not form part of the registered design. So my point in taking you to the extract from Magmatic and in making these submissions is to say the starting point must be that you look at the design, you look at the picture, and of course you interpret it to say, well, what does it show? But in circumstances where there is a very obvious feature, certainly to the uninitiated, if you looked at the 4 designs, you would say, well, one is light and one is dark. And my point is that if the respondent to this appeal did not wish to rely upon that colour, there were many things it could have done to avoid that difficulty coming up. It could have entered a disclaimer, it could have shown it in some different way, it could have taken different photographs against, it's not for me to explain to Marks and Spencer how
Essentially,
they
your
could have
point
done.
is that if the applicant for registered design chooses to include a colour in the image, then that is part of the design unless it's excluded.
Yes, exactly so, my lord. So that I say is the position we're in here. So if we then, I mean, my lord raised, of course, the question of whether the court is entitled to look at products said to be made to the design. But of course, the difficulty
Justice has told us in PepsiCo that that is legitimate.
that it is legitimate to look at it, but of course, it's also very risky to do so, because
It's different.
because the key question is the product the same or different from the registered design? And in this case, that is to look at the product to ascertain whether it is the same as the registered design is circular. We say the registered design, 2 of them have no integrated light, and that's what the judge
That would always be the case.
found.
So sorry, it's my fault, I'm sure. Can we just separate out the questions? So you accept that as a matter of law, it is permissible to look at the product to interpret the registered design.
PepsiCo
See
says,
PepsiCo.
says you can look at it to check that what you've done is right. But only if you're looking at the actual product that is made to the registered design. Now, where there is a dispute about whether the product is made to the registered design, then in my submission, the value of looking at the product is very much diminished. So we don't accept, for example, that the product you've been handed up is made exactly to any of the registered designs. In respect of the light-coloured designs, we say, well, that has an integrated light, and the judge found that the light-coloured designs 78 and 80 didn't. In respect of 82 and 84, we say, well, they show a dark-coloured liquid or a dark-coloured bottle, and that's a clear bottle. So inspecting that bottle is not going to help you, in my submission, with determining whether these features are present there or not. So if one then turns to the judgment, and we're at the judgment, sorry, look back at the judgment. At paragraphs 9 to 16, you can see that the judge is setting out various issues of law.
Yes.
At paragraph 15 and 16, the judge considers whether it's right to take into account the description light up gin bottle, and said that neither party was pressing for it, so this is all an obiter discussion on his part. But at paragraph 17 is the operative part of the judge's decision on this issue. And the judge says, I was pressed by Mr. Selmy for M&S to look at the images of the 4 registered designs in suit as they appear online, on the ground that the images there more clearly show the integrated light feature. One assumes that the judge did this, though to be fair, he doesn't expressly say so. To my eye, the 2 registrations of the images created against the dark background, i.e. UK 82 and 84, show the integrated light feature. The other 2 do not. My point here is that the judge in this whole section is focusing on whether or not there's an integrated light. What he does, he looks at the design and he comes to a conclusion saying, these 2 have the integrated light, those 2 do not. And it's really no more than a passing comment that he says, the images created against a dark background, i.e. UK 82 and 84, show the integrated light feature. So he's using the fact they have a dark background purely descriptively. He's not, in my submission, actually turned his mind to the issue between the parties as to whether this darkness arises from the liquid or the bottle or is simply background that can be ignored. And one sees this emphasised, if I invite you to turn back to paragraph 11, where he's discussing, following a short, uncontroversial proposition of law, the last 2 lines of 11, he says, the point at issue is whether one of the features of each of the RDs in suit is an integrated light at the base of the bottle.
So I understand the point you're making, but can I just ask you this question? On your submission, the way you've just put it very clearly, is the judge has failed to deal with one of your arguments at trial.
Yes.
So presumably when you got this judgment in draft, you wrote to the judge saying you failed to address one of our arguments. Please do so.
Well, what we then did, exactly, so Marks and Spencer say in their supplemental skeleton, well, we didn't raise this issue of lack of reasons.
Well, it's not a lack of reasons. The way you've just put it is there was an issue raised, it's not a question of reasoning. On your submission, he's not addressed part of your case at all.
He hasn't addressed part of it. The difficulty we have is that in paragraph 17, as I've just showed you, he does refer in passing to the images created against the dark background. And so we have done is because Marks and Spencer raised this point. So if I take you to the second supplemental bundle at tab 6, you will see that this is my skeleton before the consequentials hearing. So judgment was handed down without the attendance of the parties and
So you didn't object when you got the draft?
Adjourned, no, but it was raised prior to. So in the draft grounds of appeal here, you can see that on page 38. So this was my skeleton. It's attached draft grounds of appeal on page 36. Ground 6 is on page 38 under interpretation of registered designs. And on ground 6.2.
Sorry, page 38. Yes, got it.
Paragraph 6.2, he said the judge gave no reasons for this conclusion, even though it's contrary to the appellant's case. Now, this was filed with the court in the usual way the day before the hearing, and so
Sorry, can I be clear what you're referring to? So you just referred it to this is grounds of appeal 6, paragraph 2, and the ground is the judge gave no reasons for this conclusion.
Yes.
But the submission that you just were making, as I understood it, was not an absence of reasons, but a more fundamental point. Namely, he didn't address the issue at all.
Well, my lord, it simply depends on whether you construe what I referred to as the passing comment in paragraph 17 as a decision with no reasons, or you might say, well, actually, it wasn't a proper decision at all.
What? It's your submission. So you tell me which it is.
Well, my lord, I think you can put it both ways. And the point I'm making by showing you that these are the draft grounds of appeal sent to the judge the day before the consequentials hearing, when I stood up and asked for permission to appeal. And so the judge had them in advance of the hearing. He could see what I was going to say. And in accordance with the authorities, he had the opportunity then, if he thought there was anything in it, to provide some further reasons or to give some further explanation.
I understand
as
that.
to why.
Yes. So you clearly raised in your draft grounds an allegation of lack of reasons, and the judge didn't elaborate.
Yes.
But at the moment, I'm not seeing anything in the draft grounds that says you didn't address the issue at all. Please do so.
Well, my lord, I see it as an aspect of a failure to give reasons, because it's not as if the judge didn't even mention it, because I'm constrained by the fact that he does mention the point at issue at paragraph 17 of the judgment. But it's such a passing mention that I can't say it's not addressed at all. I couldn't have stood up and said, you've not even mentioned whether you consider this has a dark background or not, because he did. And what...
Can I just ask you a further question while we're on the topic?
Yes.
I can quite understand why you say there's an absence of reasoning, but it might be said the same goes for the integrated light feature point. Again, it's a conclusion without any reason.
Well, my lord, neither side has appealed that decision of the judge, but what happens there is...
Excuse me, it's in the respondent's notice.
I'm sorry, they have not appealed it on the grounds of an absence of reasoning.
Well, I think they do say that. It's not a distinct ground of challenge, you're right, but they certainly say this is just a conclusion without any analysis.
Well, what I would say is that we saw that he looks at the law, and in paragraph 11, he makes the point that the point at issue is whether there's an integrated light. So he clearly has that point in mind.
Yeah.
And then he's invited to look at them because it is something that you simply see with the eye. And it is, again, as I said earlier, I accept he doesn't expressly say, I went and looked at the larger images online, but he does say, I was invited to do so by Mr. Selmy. One infers that he did so, and then just says, to my eye, looking at it, the light is present here and it's not there. It's simply a question of identifying.
There's a dark background in some of the designs and not others.
Well, I would accept that there were, that it was the equivalent point if he had had that issue in mind, and if he had said so much as, I have looked closely at the designs and I consider that it's not a dark liquid or a dark bottle but a dark background, then at least we would have some kind of reasoning. And there is some kind of reasoning and some kind of process that the judge has done in relation to the integrated light. But there's no sign of any such thought process carried out in respect of this dark tint point. In fairness, I should take your lordships to the N 460, the judge's reasons for refusing the appeal, which is on the next tab, tab 12 of the court bundle. Ground 6, which we just saw, it's the same, although they were draft grounds and they differ slightly from the ones before your lordships, it's the same point. Ground 6 concerns an interpretation of the registrations on the facts. The interpretation advanced by the claimant was preferred. On that finding, each of the designs is different. But again, in my submission, that's not enough just to say this was preferred without giving some explanation of how it was preferred or on what basis or even what process the judge undertook to decide that that was the answer. The law and the requirement to give reasons, I don't think there's anything between us on this point. I've cited English and Emery Reinhold, and also the judgment of Lord Justice Kitchen in Comic Enterprises. And if I could take you to that, it's at Authorities Bundle tab 8. And it's paragraph 70 at page 204.
Paragraph 70.
70. Page 204. And you'll see this was an appeal point that the judge had failed to consider whether the services for which the mark was registered were similar to the services in respect to which the allegedly infringing mark had been used. So paragraph 70, Lord Justice Kitchen says, I accept the issue of similarity between the services was a live one at trial, and it's striking there's no consideration of it in the judgment, save at 125, where the deputy judge refers to it almost as an aside. There he says that the likelihood of confusion which he believed the evidence established accorded with his own view on seeing the mark and the sign used on, quotes, such similar entertainment services. As Ms. Purvis fairly points out, entertainment services have such been deleted. The deputy judge nowhere identifies which services he considers to be similar, why, or how it bears upon the issue of confusion. The complete absence of any reasoning does, in my judgment, amount to a material deficiency which again vitiates the conclusion to which the deputy judge came. Plainly, my lords, my submission is that we're in a very, very similar situation here, where there is a passing reference to there being a dark background. And in this case, there was a passing reference, almost as an aside, as it's put, that they were such similar entertainment services. And in this case, that was analysed as a failure to give proper reasons and vitiates the conclusion to which the deputy judge came. And in my submission, we're in a very similar situation here where there's a passing reference. My lord, so if we could please turn back to the registrations in the judgment at page 99. Just very briefly, obviously my first point is to say, well, there are insufficient reasons, so the court would have to look at it again. If you look at these images, you can see that the designs include colour, and the photographs include colour. Indeed, if one looks closely at it, there appears to, on the UK 82, on the left-hand image, there appears to be some kind of even darker, almost tombstone effect on the left-hand image, if one looks closely. There's certainly something going on, and there are no disclaimers or any disclaiming marks or anything else to suggest that that should not be taken into account. And then you look at the image, and of course the dark colour extends only to the edge of the bottle. It's not a photograph as we saw in the advertising photograph of the Marks and Spencer products, where the background is clearly visible behind the products, and one can tell that it's background. Here, the dark colour ends exactly at the edge of the bottle, which is why one would naturally construe it as forming part of the design, forming part of the colour of the bottle or the liquid. Marks and Spencer say, well, this can't be a dark colour because it's translucent, because you can see things through the liquid, such as the gold flakes. And we, in our skeleton, say, well, we simply don't accept that because, of course, you get dark and translucent liquids such as tea, or perhaps more appropriately for this case, whiskey, or brandy, or any number of liquids which could have a dark tint, but yet would allow light to pass through. And indeed, if I could take you to the supplemental bundle at page 60, tab 2, page 63, since my lord raised the issue of light up gin bottles, in case that's relevant to construction.
Sorry, supplementary bundle.
Tab 2, page 63. this is just by way of an example. You can see here that these are gin liqueurs, which also come in a variety of shades, including some quite dark shades. I'm not making any point about the translucency here, merely to show that even if one were to assess the product by reference to gin, it would not prevent it being coloured.
What one sees from this is confirmation of what's common knowledge anyway, which is you don't fill a bottle of liquid right up to the stopper. You leave a gap, and there are very good technical and commercial reasons for doing that. And we do not see any such gap in the images in question.
So if one looks at the registered design images on page 99 of the judgment, you can see that the dark colour extends to the edge of the bottle. It does indeed go up to the neck and indeed to the cork. I mean, one might look at 82 and say, and it almost seems as if the end of the cork might have been stained by contact with the liquid. But in addition, we say it might be the liquid that's inside. It might just be the dark tint of the bottle, in which case, of course, it would go, or could go, all the way up. It could be some kind of transfer applied to the majority of the bottle, but not all of it. There are various ways in which, in my submission, it could practically be done. And the natural reading of that image is to say, well, there's some kind of dark coloration on this, and that's very important. It's something that really strikes the informed user as a significant feature of this design.
How far you go on this? I quite understand. Your submission is that the proper interpretation of the images is that either there is dark liquid within the bottle, alternatively, the glass of the bottle is dark coloured. Understand both of those points. Suppose we were to conclude that neither of those is correct, and that the image is indeed of a clear bottle with a clear liquid against a dark background. So, on that hypothesis, would you still contend that the dark background is relevant to the scope of protection?
Well, my lord, it's of course a matter for the court as to how it construes the design. But
now I've given you the hypothesis as to how the design is construed.
So if there are only those three options, I would still say that there is a feature of this design. How it is, we have suggested two ways in which it might be applied. But we say it's a feature of the design is that it's presented in colour, and colour should be part of that.
Right, now how much further are you going to go, Mr. Elias? It's now 1 o'clock.
Yes, I apologise, my lord. I've been very conscious of the time while trying to deal with.
Mr. Campbell's got, and indeed Mr. Selmy have got time to make their submissions.
Yes, my lord. I can deal very briefly with ground 7.
Well, can you deal with it after the short adjournment in 5 minutes?
Sounds like I will have to, my lord. And maybe in terms of the points raised by Lord Justice Arnold, then in respect of the.
Well, one of them we've already dealt with. The other question you referred to an understanding earlier, and let me just be clear so as everybody who hasn't seen it for themselves can check it over the short adjournment. If you look online at the register, we find something which, in my experience, is extraordinary, which is the state of the register has changed since the trial. So if you look at Supplementary Bundle tab 1, page 2, by way of example, you will see in the middle of the page, it says description, light up gin bottle. And that explains why the judge says that's the description and why he comments in paragraph 22 on the absence of any indication of product. When you look at the register now, the word description is not present and the words indication of product are present. Now, I know not what the explanation for that is, but one possibility is that UK IPO, when the judgment came out, take a look, read it, thought to themselves, that's jolly odd. It's a requirement to have an indication of product. Did we slip up? They went back and decided that their register was erroneous and corrected it. That's speculation, obviously, but it would explain why the state of the register now is different. But that's a point that goes to the respondent notice.
Yes, perhaps I'll let them address it first and we'll respond to it.
Right, well, we'll leave it there for the moment and we'll sit again at 2 o'clock.
All right.